Please be seated. The sitting is open. For reasons duly made known to me, Judges Abraham and Yusuf are unable to sit with us today. The court meets this afternoon to hear the second round of oral argument of the Republic of Azerbaijan on the preliminary objections raised in the case concerning application of the International Convention on the elimination of all forms of racial discrimination, Armenia versus Azerbaijan. I shall now give the floor to Mr. Sean Oge. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of Azerbaijan. I will be responding to the evidence of so-called Armenophobia, about which you heard a great deal yesterday. Armenia confirmed yesterday that the general backdrop of so-called Armenophobia provides the critical context for assessing whether its freestanding claims are capable of amounting to racial discrimination. While Professor Murphy agreed that this is a relevant factor only, he disagreed that its relevance is as background context only. Rather, Armenia says that this overall racial animus inescapably led to the specific atrocities, that is, each and every one of what Armenia itself calls the myriad individual specific acts of violence occurring during the active hostilities phase of the armed conflict that compromise its freestanding claim for breach of the CERD. In an attempt to tie back the specific alleged killings and mistreatment to evidence of racial discrimination, Armenia argued that there is a clear continuity between official racial animus towards ethnic Armenians by Azerbaijani officials at the highest level and the racist actions of soldiers who directly committed the violence against ethnic Armenians. The top part of the seamless tapestry that Armenia seeks to weave is said to show President Aliyev's racial animus towards ethnic Armenians. You were shown a number of slides highlighting a list of specific words and phrases plucked from various speeches of President Aliyev. One of these is now on the screen. The use of selective quotations without the surrounding context does not assist the court when it comes to assessing whether the underlying documentary evidence is capable of amounting to racial discrimination, and particularly so when the relevant speeches themselves have not been included in Armenia's judges' folders. Azerbaijan has now included each of the speeches in your judges' folders at tab 2 and asks that you read them. You will see that taking the words on their face, the statements relied on are not capable of showing a racial animus towards ethnic Armenians. I turn to the statements themselves. First, Armenia asserts that in 2 speeches, President Aliyev referred to all ethnic Armenians as bandits and vandals. As you can see from the context on the screen, the statements were used to refer specifically to persons who have destroyed Azerbaijan's historical monuments. Everything on the occupied lands is destroyed. All our historical monuments have been destroyed by Armenian bandits and vandals. Vagif's mausoleum, like all other historical monuments in the occupied territories, was vandalized by the Armenians. Second, Armenia asserted that in another speech, President Aliyev referred to all ethnic Armenians as fascists. The relevant speech, in fact, again, refers specifically to the crimes committed by Armenian fascists and vandals in destroying Azerbaijan's historical and religious sites. And this was in the context of comments concerning Armenian occupying forces. In another speech that Armenia relies upon, President Aliyev referred specifically to the fascist leadership of Armenia. Third, Armenia also claims that President Aliyev referred to all ethnic Armenians as wild beasts, predators, jackals, and a wild and savage tribe. When you read these two speeches, you will see that President Aliyev called on the predatory Armenian state specifically to vacate our lands. Further, in specific reference to the destruction of an Azerbaijani city in the formerly occupied territories by the forces of the illegally installed regime in Karabakh, President Aliyev stated, and this context is on your screen, when we talk about the city of Fuzuli, of course, we should all know that there is nothing left of the city. No monuments, not a single safe building. For 30 years, it was in the hands of wild beasts, in the hands of predators, in the hands of jackals. All the buildings have been demolished. Our religious sites have been demolished. Everything has been looted. The roofs of the houses, the windows, the belongings, everything. It was as if a wild tribe had taken over the city. The remains of the city of Fuzuli are a manifestation of Armenian fascism and a witness to Armenian fascism. And please note, by way of further immediate context, the image now on the screen, showing the scene of devastation in the city of Fuzuli, to which President Aliyev was specifically referring. Returning to the same speech, as you can see on the screen now, President Aliyev also stated, "We are avenging and will continue to avenge the deaths of our martyrs, of innocent civilians on the battlefield. We have never fought or will ever wage war against the civilian population. The victorious Azerbaijani army is driving and will continue to drive the enemies away from our lands in the ongoing battles. I said that if they do not leave our lands of their own free will, we will chase them away like dogs. And we are doing that." Armenia not only ignored the immediate context that I have just shown, it also failed to draw attention to another passage in the same speech, which shows that the relevant context, the description of the enemies as dogs, an insult which you will recall Armenia placed particular reliance upon, as you can see from its slide now on the screen. It shows that this is plainly not a reference to ethnic Armenians, but to the Armenian occupying forces waging war and the leadership directing those operations. The statements were in reaction to the shelling of Azerbaijani cities of Ganja and Mingachevir earlier the same day, and the context for this, taken also from President Aliyev's speech, is now on the screen. Despite the fact that the cowardly, treacherous and vile enemy commits war crimes, fires upon the civilian population and kills children, as a result of today's shooting, I want to say again that we must not take our revenge on civilians. We are taking our revenge on the battlefield. I warn the fascist leadership of Armenia again, leave the remaining lands of your own accord. We will throw you out of there anyway. There will be no trace of them left on those lands. We will drive them out of our lands to the end. Let them leave of their own accord. You were also not told that in a publicly available interview with the BBC on the 9th of November 2020, around 3 weeks after President Aliyev made these statements, and around 1 year before Armenia filed its application in the present case, President Aliyev specifically addressed the meaning of the phrase, "We will chase them out like dogs." A transcript of that interview is included at tab 2 of your judges' folders, and the relevant extract is now on the screen. With respect to the Armenian population of Nagorno-Karabakh, they will continue to live there. They are our citizens, and I on many occasions expressed this position. The interviewer then says, "Well, with respect, President Aliyev, you are saying that the Armenians will consider to live there as your citizens. You have very recently said, and I'm quoting you here, if they do not leave, we will chase them like dogs. Now, that's hardly the kind of statement that would make people feel safe. No. Please be accurate with my statements. What I said, I meant those who continue to occupy our territories. I meant Armenian military political leadership. I meant the so-called authorities of Nagorno-Karabakh, this criminal junta. So I meant them. I didn't mean Armenian people. Later that month, Azerbaijan's foreign minister provided the same explanation in another publicly available interview, this time with the French magazine Le Point, which is also in your judges folder at tab 2 and on the screen, and to which again your attention was not drawn. Fourth, Armenia's agent also highlighted the following statement by President Aliyev in another speech. What was driving us forward? Our patriotism, love of country, and hatred for the enemy. But the agent did not mention that the enemy referred to is said to be the occupying enemy, that was forced to sign an act of capitulation with its own hands, and that is plainly a specific reference to the forces of the illegally installed regime. And nor did Armenia refer to President Aliyev's statement in the same speech, we have never fought and will never fight against civilians. Fifth, Armenia also claimed that President Aliyev has declared Armenians of the world to be Azerbaijan's main enemies. Again, this statement needs to be read in its context, which is now on the screen. Thank you. Our political influence and economic power are growing. This is seen by those who like us and those who don't. There are quite a lot of those who rejoice in our successes, but there are forces that don't like us, our detractors. They can be divided into several groups. First, our main enemies are Armenians of the world and the hypocritical and corrupt politicians under their control. The politicians who do not wish to see the truth and are engaged in denigrating Azerbaijan in different parts of the world. Here, the word enemies is being used to mean nothing more than detractors, that is, various groups that denigrate Azerbaijan. One of those groups, Armenians of the world, is being identified not on the basis of a shared ethnic origin, but on the basis of their support for and association with certain politicians who disparage Azerbaijan. Sixth, and lastly, so far as concerns President Aliyev's statements, Professor Murphy stated that just last month, President Aliyev referred to the lighting of a bonfire in what he called the liberated lands of Nagorno-Karabakh as also doing the final cleaning. But you were not provided with a transcript of the relevant video in Armenia's judges' folders, and this is now included at tab 3, and the context is also on the screen. President Aliyev used the term final cleaning in specific reference not to ethnic Armenians, but to the demolition of the parliament of the illegally installed regime and other government buildings of that regime in the formerly occupied territories. It is also to be noted that some of the insulting language in the transcripts upon which Armenia has relied have likewise been taken out of context. For example, at paragraph 48 of its observations, and again yesterday, Armenia refers to a video purporting to show Azerbaijani soldiers mutilating the body of dead Armenian soldiers and claiming that Armenians are sons of dogs and that he came here to cut off the seeds of these immoral people. But the transcript shows the immorality not to concern Armenian ethnicity, but rather previous acts of Armenian soldiers in the course of active hostilities. Armenia's own transcript reads, "You are now answering with your ears for the immorality you did yesterday. I came here for one purpose, for cutting off the seeds of these immoral people to taking revenge." It is also curious that some of the derogatory language in Armenia's description of its video evidence in Annex 290 to its memorial and tab 3 of Armenia's judges' folders, in fact, does not appear in the video. To take one example, Armenia describes one video as recording the shocking mistreatment of Armenian prisoners of war by Azerbaijani soldiers who use the words, "you, the disgraceful people." But the word people is not used, and the words that are spoken are insults directed against the Armenian servicemen. As a final matter to address on the way Azerbaijan puts this objection, it was said by Armenia that it makes little sense for Azerbaijan to accept that the claim in respect of hate speech is capable of falling within CERD, but that the same speech, when used in connection with violence, did not provide the necessary racist animus. 2 points. First, this has no bearing on the broader concern which Mr. Wordsworth explained on Monday and to which he will shortly revert. Second, Armenia has put forward a claim concerning, quote, systemic hate speech. Azerbaijan understands the claim to be one concerning an alleged existence of an unlawful policy or practice of hate speech, with the multitude of statements being put forward as illustrative examples. Since, as Mr. Wordsworth explained on Monday, the court's jurisdiction over a claim of that nature does not depend upon showing that each and every statement is capable of amounting to racial discrimination, Azerbaijan made no preliminary objection to this claim, which it is confident of defeating at the merits stage. This in no way entails that Azerbaijan has accepted that each and every such statement that has been characterized by Armenia as hate speech, including the statements of President Aliyev, is capable of amounting to racial discrimination. Everything depends on the context, including the immediate context in which the given term was used, which may simply have been to refer in a derogatory way to the members of the enemy armed forces or to the illegally installed regime. As I have just shown, the immediate context in which the various statements of President Aliyev were made plainly shows that these were not capable of demonstrating a racist animus on his part towards ethnic Armenians. A final point. Yesterday, Armenia's agent asserted that Azerbaijani public officials continue to call for the complete elimination of ethnic Armenians. He did not footnote to any particular statement, and that is because Azerbaijani public officials have in fact been calling for peace, mutual understanding, and mutual respect between the Azerbaijani and Armenian populations of Karabakh. An example of this, taken from a speech by President Aliyev on the 20th of September 2023, using that language, is on your screens. And this was just one of many such statements from senior Azerbaijani officials over recent months. Mr. President, members of the court, I thank you for your attention and ask that you call Mr. Wordsworth to the podium.
I thank Mr. Ogay for his statement. I now invite Mr. Samuel Wordsworth to take the floor. You have the floor, sir.
Thank you. Mr. President, members of the court, I will be responding on the issues of law and fact raised by Armenia on Azerbaijan's jurisdictional objection to Armenia's freestanding claim for breach of CERD through alleged discriminatory murder, torture and inhumane treatment of ethnic Armenians. It is important to identify up front what Armenia is asking this court to assert its jurisdiction over and rule upon at the merits phase. That is, each one of the multiple alleged but not yet particularized instances of mistreatment of Armenian military personnel and civilians in the Second Karabakh War and in all other phases of the active hostilities. Yesterday, Armenia did not seek to confine or clarify its claim in any way. The two examples I gave you on Monday of what is alleged by Armenia to be in breach of CERD were just ignored. That is, the allegedly deliberate use in the military operations of weapons causing extensive and indiscriminate harm to civilians, and the alleged use in September 2002 of heavy artillery and drones to target not only military units and installations, but also towns and villages on the Armenian side of the international border between Armenia and Azerbaijan. Plainly, such conduct is indeed included within the freestanding claim of breach of CERD. There was no attempt to address Azerbaijan's concern, which, to recall, is that through the allegation of use of a certain type of weapon and of indiscriminate harm more generally, that is, matters plainly governed by IHL, Armenia is seeking to begin within CERD the entirety of a period of active hostilities, thus establishing a wholly open-ended jurisdiction with respect to, for example, alleged violence caused to civilians of Armenian ethnicity. And it is plain that this concern was not and could not be addressed yesterday because this is exactly what Armenia is seeking to do. The court heard countless times yesterday that all Armenia's allegations of fact must be accepted as true at this stage, and hence, in effect, the court must accept at this stage that there is Armenophobia, that this operates and prevails from the top to the bottom of Azerbaijan's government and military, such that all actions of Azerbaijani soldiers that result in allegedly indiscriminate or targeted violence against Armenian civilians, or the mistreatment of Armenian military personnel are motivated by racial discrimination. Any closer inspection, it said, must await the merits. On the basis of what you've just heard from Mr. Oki, it is easy enough to see why the court is being asked to assume that absolutely everything that Armenia alleges is true, but that does not mean that this is the correct approach. I will address the issues in the following order. First, it is important to identify the various mischaracterizations of Azerbaijan's jurisdictional objection that you heard yesterday, and to recall how Azerbaijan, in fact, puts its case, dealing along the way with the somewhat bizarre contention that Azerbaijan has not put forward genuine jurisdictional objections, and in light of Armenia's objections, is simply hoping that the two sets of objections will cancel each other out. Second, it is necessary to revisit briefly the applicable legal test and identify how Armenia is seeking to pull back from the position it adopted in its written pleadings. And finally, I will explain how Armenia's freestanding claim does not satisfy the applicable legal test. Turning then to the mischaracterization of Azerbaijan's objection, it was said by Professor Murphy yesterday that Azerbaijan is apparently is seeking from you a ruling that any violent abuse by Azerbaijan of ethnic Armenian soldiers connected to hostilities, even if undertaken in conjunction with extraordinarily hateful and vile racial rhetoric, is utterly incapable of violating the CERD. To similar effect, he implicitly recognized the force of Azerbaijan's concern that the very low jurisdictional threshold for which Armenia advocates would facilitate CERD claims with respect to all apparent breaches of IHL in an armed conflict involving two states that are primarily of different ethnic origins. However, he stated, but consider as well the result of Azerbaijan's preferred approach. Any party to an armed conflict could commit unspeakable racially motivated abuse against soldiers and civilians alike, and yet not be held accountable under the CERD. Well, that is not, of course, a remotely fair reflection of the way Azerbaijan frames its jurisdictional objection, which has two limbs. So far as concerns Armenian civilians, the objection is to the freestanding claim of breach of CERD concerning the alleged mistreatment of civilians during the active hostilities phase of armed conflict, in relation to which Armenia has presented no specific evidence of purported misconduct on the basis of ethnic or national origin. Azerbaijan is simply saying that the claimant has to tie back alleged mistreatment to some specific evidence of racial discrimination. And that follows very naturally from the wording of Article 1.1 CERD. As to the objection concerning alleged acts against Armenian military personnel in the course of active hostilities, Azerbaijan is not, of course, saying that anything goes on the battlefield so far as CERD is concerned, or that CERD is somehow displaced by the rules of international humanitarian law. And it is curious that Armenia, both through Professor Murphy and later through Ms. MacDonald, is seeking to suggest otherwise. Azerbaijan's position is merely that, so far as concerns the particular allegations made by Armenia in this case, it has not made an adequate showing of mistreatment based on racial discrimination so as to engage jurisdiction under CERD. The point was made yesterday, as if it were a point in Armenia's favour, that Azerbaijan does not object to most of the claims made by Armenia. And a slide to that effect was briefly put up on the screen. And it can usefully be shown with a little more time now to consider it. Certainly, Azerbaijan's objection has been carefully confined, and a brief review of Armenia's slide shows that Azerbaijan is not objecting to what amount to a series of claims concerning alleged policies and state practices with respect to ethnic cleansing, supporting violence, inciting hatred, the withholding of civil and political rights, the state's failure to meet its positive obligations and to provide effective remedies. These are recognisable as matters capable of falling within CERD. And although Azerbaijan is certain of defeating these claims in due course, these are claims that are manageable, both in terms of Azerbaijan knowing the case that it has to meet, and also for the court in terms of making its ultimate determinations. By contrast, Armenia's claim on discriminatory killings and mistreatment is not, and is quite deliberately not, a claim with respect to an unlawful campaign or practice, as to which the court could seek to identify at the merits phase whether there was some racial animus driving an alleged practice, together with sufficient evidence of implementation of that practice on the ground. Instead, the claim that has been put before you by Armenia has no filter. As Armenia put it yesterday, Armenia has alleged multiple acts that, taken as true at this preliminary stage, each independently violates the CERD, and at minimum are certainly capable of constituting violations of the CERD. And as the court will know from having looked at Armenia's memorial, by multiple acts, Armenia does not mean a dozen or several dozen, it means many, many more, because the court is being asked to examine the entire conduct of the Second Karabakh War and other periods of active hostilities, and to rule on an unstated but very high number of what are apparent breaches of IHL or human rights norms, all on the basis that these are said to be generated by racial discrimination. To make this point good, it is useful to look at paragraph 6.82 of Armenia's memorial, where it starts to plead out its case on breach concerning alleged discriminatory killings and treatment. It says, for the sake of brevity, Armenia does not repeat below the myriad acts of violence against ethnic Armenians, of which detailed descriptions are set forth in parts 3 and 4 of this memorial. Some 480 pages, by the way. Instead, Armenia explains how different categories of violent acts against ethnic Armenians constitute breaches of the CERD during 3 distinct periods. And then you see the different categories, in respect of each of which there are then multiple references back to parts 3 and 4 of the memorial. The same basic point follows from paragraph 47 of Armenia's written observations, where it says the direct evidence of Azerbaijan's racially motivated violence and other abuse is too copious to recount in full. Armenia therefore directs the court to the following section of its memorial, 3.1.2, 3.2.2, 3.3.1, and so on. Then it continues. It is important to note, however, that as explained in section 4 below, the entirety of Armenia's application, memorial, and accompanying evidence is relevant context in evaluating Armenia's claims. And this direct evidence includes the multiple allegations of indiscriminate shelling and other apparent breaches of IHL said to be racially motivated and hence within the court's CERD jurisdiction, even though in a very great many of the individual instances there is no specific evidence of racial discrimination. But it is said any alleged episode of indiscriminate shelling is an individual breach of CERD, every alleged use of cluster munitions, and so on. And that is why Azerbaijan makes this objection, not as part of some cynical ploy, as was regrettably suggested yesterday. Notably yesterday, Armenia also sought to have it both ways and suggested that one can certainly look at our evidence and reach a conclusion that the conduct of which we complain was widespread or systematic in nature. But that is not the claim that Armenia has pleaded, unlike, for example, in Ukraine and Russia. And as we pointed out on Monday, that would be a more difficult claim for Armenia to make out at the merits phase. And if this is all serious, and if Armenia is intending to seek to amend its claim, Azerbaijan looks forward to that being made clear on Friday. It should be noted here that the claim that Azerbaijan has put before you, which the court will be focusing on next week, is, by contrast, a manageable claim that concerns, so far as is relevant, a campaign of ethnic cleansing. And it is to be emphasised that although you heard from Armenia yesterday multiple allegations of horrific mistreatment, the allegations that Azerbaijan makes are not less horrific. Rather oddly, it was asserted by Armenia that the challenge for Azerbaijan is that it has no videos of racist atrocities to show and no pervasive hate speech by public officials to quote, as if that were either correct or could be relevant at this stage. As the court will be aware, and for what it is worth, Azerbaijan has also submitted multiple videos of atrocities against Azerbaijanis by the Armenian military that show what it considers to be evidence of racial discrimination, alongside evidence of hate speech. There are very serious allegations of atrocities from both sides that could be reflected in alleged widespread breaches of international humanitarian law or human rights. But the important question for now is whether these have been put before you as recognisable and manageable cert claims, or instead as an unrecognisable and unmanageable series of entirely open-ended claims covering all allegations of unlawful violence against combatants or civilians in the active hostilities phases of an armed conflict. No doubt alive to this very real issue, Professor Murphy also contended that there is no need for the court, even at the merits stage, let alone at this stage, to adjudicate each and every underlying act at issue. And for support, Armenia relied on the court's finding in DRC and Uganda that, in that case, it is not necessary for the court to make findings of fact with regard to each individual incident alleged. Yet this statement was, of course, case-specific, and it has been taken out of context. The claim in DRC and Uganda, which had been brought before the court pursuant to Article 36(2) of the statute, was specifically pleaded as one for massive human rights violations. And the court found the coincidence of reports from credible sources sufficient to convince it that massive human rights violations and grave breaches of international humanitarian law were committed. Thus, there is no appropriate analogy to this aspect of Armenia's claim. The claim in the DRC case would be equivalent to a claim of a practice of racial discrimination, where the court finds that the practice is made out without having to decide on each individual instance relied on. That is precisely in line with the distinction that I was seeking to draw out on Monday, and does not assist Armenia with respect to its case on killings and inhuman treatment, as to which it is expressly putting forward a very lengthy series of individual allegations. Finally, on how Azerbaijan actually puts its objection, there were various non-serious assertions as to a lack of clarity, including as to Azerbaijan's letter of 5th April 2024. We do not accept those, and insofar as there was any real doubt when Azerbaijan refers to the combatants in the active hostilities phase of the armed conflict, it of course includes the combatants in the so-called NKR Defence Army. Indeed, it has been found as a fact by the European Court of Human Rights that the Armenian Armed Forces and the NKR are highly integrated. I turn to the applicable legal test, as to which there is much common ground, and there are 2 points to be made. First, as Ms. MacDonald stated, the court's task at this stage is to look at Armenia's claims, look at the evidence and say, is this capable of amounting to racial discrimination? And that is a fair description of the court's task. At the same time, however, Armenia's counsel repeated again and again that the facts pleaded by Armenia should be assumed to be true. And Professor Dargent stated that it is therefore totally unnecessary at this stage to delve into linguistic exegesis or to assess the meaning of certain remarks, and that it is equally erroneous to argue that Armenia has not provided sufficient evidence at this stage, because that requires an assessment of the evidence, which can only be done at the merit stage. If this is seeking to erect a no-entry sign, and that does appear to be the case, it is both notably defensive and inappropriate. A key question at this stage is whether the evidence presented by Armenia of the use of certain statements in connection with specific conduct shows that the conduct is capable of being based on racial discrimination. Thus, the court must look at the underlying and assess for itself whether the relevant statements relied on the face of the specific language used in its context, is capable of amounting to racial discrimination within the meaning of Article 1.1 Cert. This should be self-evident and in no sense cuts across the Court's established jurisprudence that it is not appropriate at the jurisdictional stage to weigh the evidence against any other evidence or argument, or otherwise to assess its plausibility. And if it were otherwise, a claim for breach of cert could be brought into existence by a combination of pleading and assertion that documents relied on show racial discrimination. Indeed, Armenia must accept this as the basic approach, because it included some of the underlying evidence in its judges' folders and invited the court to read these. Azerbaijan is not asking the court to dive into linguistic exegesis or a critical examination of Armenia's evidence. It is merely relying on what it understands to be a common ground position that the court must look at a document for the limited purpose of identifying what it in fact says on its face. And that exercise is all the more important, whereas here, one party has picked out particular phrases from the underlying documents and presented those statements without the surrounding context. The second point on application of the legal test concerns the current specific context of an armed conflict where the peoples of the two states are primarily of different ethnic origins. Here again, there is significant common ground. Paragraph 6 of Armenia's written observations reads as follows. Azerbaijan itself acknowledges that acts that violate international humanitarian law may also violate the CERD, but nevertheless asserts that the mere fact that the peoples of two states at war often are primarily of different ethnic origins does not, without more, transform every act of war into a distinction based on ethnic origin. Armenia agrees. Armenia does not agree, however, with Azerbaijan's assertion that the allegations in question potentially raise questions under IHL but not under CERD. Hence, which should be common ground, the need for the something more. Yet it appeared to be suggested at various stages yesterday that it was sufficient for the purposes of CERD that there be allegations of mistreatment within the context of an armed conflict where the two sides are primarily of different ethnic origin. Curiously, Professor Dargent appeared to criticize Azerbaijan for refusing for 3 decades to recognize the self-determination of Armenians living in Karabakh, although that refusal was of course shared by the entire international community other than Armenia. He alleged that there had been numerous discriminatory violations and ethnic cleansing, and then suggested, perhaps rather colourfully, that he could end his speech there. Such an argument might have been a starting point for a response to a jurisdictional objection to a claim for ethnic cleansing, but that is not an objection that has been brought by Azerbaijan. It was also suggested that Azerbaijan is seeking to reverse the burden of proof because it is saying that it is necessary for Armenia to show the something more. Yet all Azerbaijan is doing is refer to what has been agreed between the parties. I turn finally to application of the legal test to Armenia's freestanding claim of alleged killings and mistreatment. Armenia's principal answer, on which Professor Murphy spent considerable time yesterday, is its case on the so-called general Armenophobia, which Mr. Ochi has already focused on. This is the critical pivot for its argument that its freestanding claim for killings and mistreatment is a CERD claim. And to be clear, it is absolutely reliant on the so-called Armenophobia. Without this, What is there to say that the alleged indiscriminate shelling of a certain village in the course of active hostilities, or likewise the alleged murder of civilians, falls within CERD as opposed to the rules of IHL or other human rights norms? It was asserted by Armenia yesterday that Armenia has presented abundant direct evidence of the racial motivation behind each and every claim it has asserted. But with respect, that is plainly wrong. Indeed, it was contradicted shortly afterwards when it was stated that Armenophobia helps to explain why racial animus was expressly articulated when much of the conduct occurred. It helps to explain why implying racial animus to other comparable conduct is entirely appropriate. Thus, Armenia accepted what is obvious. It is using the alleged Armenophobia to imply racial animus, or to put the matter a little less coyly, to fill a large gap in its pleading. Yet the evidence that is being relied on to support the existence of the so-called Armenophobia fails on its face to show racial discrimination, and an allegation of Armenophobia is inadequate to fill the evidentiary gap. Or, as it was put yesterday, again with some colour, to constitute overwhelming evidence of the racial hatred underpinning the atrocities committed by Azerbaijan. And to recall that ambitious description was very important in Armenia's attempt to address the question that has to be asked. If Armenia's allegations, covering all allegations of mistreatment in the armed conflict, fall within the court's jurisdiction under CERD as a freestanding claim of killings and violence, which equivalent claims in any other given armed conflict will not? The inadequate answer, other than the mischaracterizations of Azerbaijan's case, to which I've already referred, was that Azerbaijan's conduct constitutes racial discrimination of a kind rarely seen in recent memory. Hence, a great deal hangs on the evidence of the so-called Armenophobia. That is why Armenia spent so much time on it yesterday, and why Azerbaijan has just spent some time actually examining the underlying evidence. Azerbaijan was also invited to accept that the alleged deliberate killing of elderly ethnic Armenians by Azerbaijani soldiers in the course of the Second Karabakh War and in the active hostilities of April 26 were capable of falling within CERD. But as horrific as these instances appear, there is nothing whatsoever to link these acts to racial discrimination. Armenia's second line of argument is to say that in certain specific instances, it has tied individual allegations of mistreatment back to evidence of racial discrimination. Although again, great weight is placed on the alleged Armenophobia as supposedly having a top-to-bottom pervasive effect. Various words and phrases were shown on the court's screen, while at tab 3 of its judges' folders, Armenia presented its self-serving descriptions of Armenia's videos. To recall one example, which was presumably seen as Armenia's best example because it's the first example in its paragraph 48 of its written observations, is the one of the Azerbaijani soldier allegedly saying, "We will eliminate your race as well." We ask you in due course to read the certified translation that Azerbaijan has just submitted to the registry, from which the impression is very different, as there is plainly a discussion of revenge for having killed our strong guys, and the words that Armenia relies on are correctly translated as "we will destroy their type." The scene is horrific and disgraceful, but it is not racially motivated violence in the way that it is being portrayed by Armenia. And it is not a matter that suggests that everything needs to await closer inspection on the merits. The transcripts of the videos are not long. It is not necessary to read them all, and the court will be able to see for itself in short order whether they appear as evidence of racial discrimination, or rather of derogatory language and insults that could be expected in active hostilities between bitterly opposed foes. And the same applies to the witness evidence in Annex 291, that is at tab 4 of Armenia's judges folder, which we also ask you to read with care. What Armenia is not able to do is to tie the alleged killings and mistreatment back to the racist language that it would wish to rely on, such as, "We will eliminate your race." Mr. President, members of the court, I thank you for your attention and ask you to call on Professor Poisson de Chazon.
I thank Mr. Wordsworth for his statement. Je donne la parole à Madame la Professeure Laurence.
I would like to give the floor to Professor Laurence Poisson de Chazon. Madam, you have the floor. Mr. President, Madam Vice President, members of the court, it is an honor for me to appear before you once again on behalf of Azerbaijan. During this second roll of pleadings, I shall confine myself to addressing a few points so as to rectify some of the remarks made by Armenia's counsels concerning this court's jurisdiction ratione materiae underserved with regard to arbitrary detention on grounds of ethnic discrimination and enforced disappearance on grounds of ethnic discrimination. First, I will address Armenia's claims that Azerbaijan has arbitrarily detained persons of Armenian origin. Let us first go back to the distinction between conduct that gives rise to a violation of IHL and conduct that is likely to fall under cert. This distinction needs to be made when dealing with situations of armed hostilities and armed conflicts. Yesterday, Armenia argued that IHL is completely irrelevant when determining whether acts of arbitrary detention and enforced disappearance are likely to fall under the scope of the provisions of cert. Armenia seems to suggest that if a prisoner of war is detained during an armed conflict, IHL rules are not implicated. Similarly, Armenia also seems to suggest that if a civilian is held during armed conflict, this does not implicate rules of international humanitarian law. However, Armenia's allegations on arbitrary detention relate to individuals who have been held as prisoners of war or due to their alleged illegal activities. And a large majority of them are individuals detained during and following the Second Karabakh War. In this context, it is difficult, to say the least, to accept Armenia's assertion that IHL would be irrelevant. Azerbaijan argues that, on the contrary, IHL has everything to do with Armenia's allegations, according to which Azerbaijan was allegedly engaged in a practice of discriminatory arbitrary detention. If cert can apply in the context of armed conflict, so can IHL. What needs to be emphasized is that in the case of armed conflict and armed hostilities, IHL necessarily applies. Furthermore, IHL is dense and may contain more specific provisions which are then applied instead of other norms. This is the case with detention. The Third and Fourth Geneva Conventions govern in detail questions related to detention, the first with regard to the treatment and repatriation of prisoners of war, and the second with regard to internment or detention of protected persons. I shall confine myself to Articles 4, 5, 12, 16, 21 and 118 of the Third Geneva Convention, and to Articles 13, 27, 42, 43, 78, 132 and 133 of the Fourth Geneva Convention. Allegations of wrongful detention must be decided by referring to these provisions. In its advisory opinion on nuclear weapons, this court had emphasized that, and I quote, "In principle, the right not arbitrarily to be deprived of one's life applies also in hostilities. The test of what is an arbitrary deprivation of life, and this is when lex specialis, the law applicable in armed conflict, which is designed to regulate the conduct of hostilities, applies. And the court considers saying that it can only be decided by reference to the law applicable in armed conflict and not deduced from the terms of the convent itself, that it can be decided whether a particular loss of life through the use of a certain weapon in warfare is to be considered an arbitrary deprivation of life contrary to Article 6 of the Covenant." End of quote. A similar situation arises in the present case. In the court's words, the test of what constitutes arbitrary detention must be determined by the applicable lex specialis, that is to say, the law applicable in armed conflict. The court must examine the allegation of practice of discriminatory arbitrary detention by referring to law applicable in armed conflict and not with reference to the provisions of CERD. For the sake of completeness, Azerbaijan specifies that it is in no way suggesting that the court cannot refer to the rules of IHL for the purposes of interpretation. Moreover, it is indisputable that if the court's jurisdiction arises from Article 22 of CERD, this court cannot rule on possible violations of international humanitarian law. This court has clearly emphasized this in its recent judgment in Ukraine versus Russia. The question, therefore, is, and that is provided Armenia's allegations were considered to be well-founded, which Azerbaijan contests, the question is, what body of norms would they implicate? Azerbaijan's answer to this question is that Armenia's allegations, should they be considered as well-founded, raise questions related to violations of international humanitarian law. When Azerbaijan, the vast majority of whose population is made up of persons of Azerbaijani origin, engages in an armed conflict with Armenia, whose almost entire population is made up of ethnic Armenians, prisoners of war on both sides are bound to be prisoners of war of ethnic origin. As a result, it is not sufficient to transform an allegation into a claim under CERD simply because a prisoner of war belongs to an ethnic group. Given that it is IHL that applies to situations covered by Armenia's allegations and not CERD, the court should distinguish between claims governed by IHL and those that fall under CERD. As to allegations of violation of IHL, the court's jurisdiction ratione materiae is unlikely to be established. However, the evidence produced by Armenia clearly shows that all the detainees were captured during active hostilities or due to their alleged unlawful activities. The second objection to the court's jurisdiction ratione materiae must therefore be upheld. Referring to the European Parliament's resolution of the 20th of May 2021 on prisoners of war following the most recent conflict between Armenia and Azerbaijan, and Resolution 2391 of 2021 of the Council of Europe's Parliamentary Assembly on the humanitarian consequences of the conflict between Armenia and Azerbaijan, the Karabakh conflict, Armenia has asked the court to take, and I quote, a cursory glimpse at these resolutions, which would clearly show, according to Armenia, that its allegations are likely to fall under said. As you can see on the slide, these resolutions were addressed to both parties involved in the armed conflict. And they call on the parties to respect the Geneva Convention, not CERD.
On several occasions, Armenia has also cited the 2022 final observations of the CERD Committee, arguing that they are highly relevant in order to determine whether any particular conduct has breached CERD. Azerbaijan does not share that opinion. As it was pointed out last Monday, the observations of the said committee are of no assistance to the court with a view to establishing its jurisdiction under CERD. Indeed, as the court noted, the CERD committee relies on allegations but does not check whether or not they are true. Hence, the court cannot accept evidence such as the CERD Committee's observations in order to ascertain whether allegations fall under CERD. Otherwise, there would be a risk that the possibilities offered by the committee might be misused or possibly manipulated in an attempt to meet the threshold requirements to establish the court's jurisdiction under CERD. In other words, Armenia cannot use the CERD Committee's observations to circumvent the regulations laid down in Article 1, Paragraph 1 of CERD, or to transform its allegations into claims under CERD. Armenia has also contended that Azerbaijan's judicial system discriminates against Armenians on grounds of their ethnic origin. But, as was stated last Monday, it is this very same judicial system which refused to uphold charges against Armenian detainees for lack of evidence, which dropped the charges against Armenian detainees, or again, which commuted sentences of Armenian detainees. The trials were held in public. The hearings, indeed, were streamed and were accessible to the public, and representatives of the International Committee of the Red Cross, the Diplomatic Corps, the Azerbaijani mediator, and the international media were present. Armenia also referred to the trial and conviction of Mr. Viken Uleshkian as being, and I quote, illustrative of Azerbaijan's discriminatory subjection of ethnic Armenians to arbitrary detention. As regards the assertion that Mr. Viken Uleshkian is a civilian detainee, I refer to tab 4 of the judge's folder and the slide on the screen. There are photographs of Mr. Viken Uleshkian taken from an open page on the social network Facebook. The latter is wearing military fatigues and carrying military-grade weapons. Are these photographs those of a civilian? Yet, that was how Armenia's counsel described him. Moreover, Armenia argued that its allegations of detention on grounds of ethnic discrimination go further than the two categories of detainees mentioned by Azerbaijan in its preliminary objections and contain unfounded allegations regarding the purported detention of individuals who, upon their arrival in Azerbaijan, were detained and who were not Armenian citizens, but were Russian or from other nations. To substantiate its allegations, Armenia relied on a press release published in 2017 by the Russian Ministry of Foreign Affairs, which concerned so-called discrimination with regard to Russian citizens. Armenia also relied on cases of alleged discrimination against foreign citizens coming from Turkey, the USA, Estonia, or Russia, who it claims were detained by Azerbaijan. Nonetheless, these examples do not show that these people were detained as a result of their Armenian ethnic origin. On the contrary, these cases highlight Armenia's strategy in this case, i.e., to rely on remote and unrelated evidence in order to build a narrative according to which Armenian nationals were allegedly arbitrarily and in a discriminatory manner detained on grounds of their ethnic origin. But Armenia cannot transform routine identity checks carried out by border guards, customs authorities at entry ports or in airports in Azerbaijan into allegations concerning the interpretation or application of CERD. In its memorial, Armenia provides no context with regard to the detention of so-called individuals with Armenian surnames in order to substantiate its assertion that detention were based on ethnic origins. Azerbaijan's president clarified and pointed out that Azerbaijan has no entry restrictions based on ethnic origin. Hence, the court at this stage should summarily dismiss these unfounded allegations as they are not likely to fall within the scope of CERD. Mr. President, I would now like to address another point which was raised by Armenia. Indeed, Armenia contended that Azerbaijan had not challenged its assertion that, and I quote, Azerbaijan has failed to guarantee equal treatment by its justice system, and that if Armenia's claims of unequal treatment in the justice system fall within the CERD, Armenia's claims of discriminatory detention predicated on unequal treatment in the justice system must fall within the CERD as well. In response, I would like to point out that Armenia's allegations concerning equal treatment and the justice system are part of its submission number 7, i.e., and I quote that submission, Azerbaijan has violated the CERD by failing to guarantee without discrimination the civil, political, economic, social and cultural rights of ethnic Armenians. As is obvious, this submission includes several allegations, and Azerbaijan will review them subsequently during proceedings on the merits. In any event, insofar as allegations concerning the procedural rights of Armenian detainees are concerned, these allegations fall within Azerbaijan's preliminary objections. Armenia also argues that the court cannot rely on reports with a general content which do not constitute first-hand evidence. Indeed, to use these documents in order to assess the Azerbaijani judicial system to ascertain whether each Armenian detainee was granted fundamental rights and due process or not. Mr. President, I now turn to the question of enforced disappearances, which constitute the third objection to your court's jurisdiction ratione materiae. As a reminder, CERD can only be invoked if it is established that the enforced disappearances are connected to practices of ethnic discrimination. Yet, as Azerbaijan has stated, there is evidence which shows that allegations by Armenia of ethnically based discrimination with respect to enforced disappearances are unfounded, and Armenia does not adduce any evidence to the contrary. Armenia has contended that this evidence shows, and I quote, dozens of ethnic Armenians, including both servicemen and civilians, have disappeared between the beginning and the Second Karabakh War and the filing of its memorial. It also asserted that at least 20 Armenians of ethnic origin have been killed since the Second Karabakh War, and that allegedly Azerbaijan has not acknowledged the circumstances of their death. Armenia is indeed pushing the boundaries of CERD too far. In substance, Armenia asserts that anyone who unfortunately went missing after or during the war is an enforced disappearance. In addition to the fact that the identity of any person involved in a conflict between Armenia and Azerbaijan is either Armenian or Azerbaijani, there is no specific evidence showing that Azerbaijan has refused to admit deprivation of liberty or has concealed the fate or whereabouts of missing persons depending on their ethnic origin. If such was the case, why indeed would Azerbaijan have returned bodies, as I shall recall very shortly? Azerbaijan has always cooperated with ICRC representatives in order to facilitate search and repatriation operations. To substantiate its allegations, Armenia also referred to the video recording of an Armenian out of action. Once again, Armenia is mistaken. The Office of the Military Prosecutor of Azerbaijan has opened criminal investigations and the proceedings are pending. Asking your court to consider that it has jurisdiction with regard to an alleged practice of enforced disappearances without any specific evidence highlighting different treatment based on ethnic origin does not allow one to claim that the impugned conduct is likely to fall within the scope of CERD. On Monday, I recalled that Azerbaijan had handed over bodies to Armenia following the armed hostilities between the two states. Moreover, Azerbaijan is willing to cooperate with Armenia for search for missing persons in both countries, regardless of their status. And I refer to the document contained in tab 5 of the judge's folder. This document also reminds us that almost 4,000 Azerbaijani citizens went missing during the First Karabakh War, and to this day only 25 persons have been identified. The facts which I have just outlined show clearly that there is no practice of discrimination based on ethnic origin with regard to disappearances. Armenia's allegations concerning the second and third objections of lack of jurisdiction ratio materia of your court therefore do not implicate CERD. These objections must therefore be maintained. Mr. President, members of the court, this brings me to the end of my presentation. I thank you for your kind attention. Mr. President, may I ask you to give the floor to Professor Talmon.
Boisson de Chazourne pour son intervention, and I will now invite Professor Talmon to take the floor. You have the floor, sir.
Monsieur le Président, Madam Vice President, distinguished members of the Court. My task today is to respond to Armenia's observations made in response to Azerbaijan's first preliminary objection, Armenia's non-fulfillment of the negotiation precondition. Yesterday, you were told by Armenia that this objection was simply not serious. This is far from wrong. This objection is not just serious, it is fatal to Armenia's application. I do not need to go over the history of the exchanges between the parties again. The facts speak for themselves. There is no question of Azerbaijan distorting reality. I would invite the court to revisit the timeline provided at tab 1 of Monday's judges folder and study the actual contents of the parties' correspondence and the subject matter of their meetings. Fact is, whatever Armenia may claim now, it only agreed to an abridged schedule of 2 days of presentation for each party without mention of any further meetings. It is also important to note that Armenia did not dispute the fact that the actual presentations of both parties' positions lasted less than 7 hours. The parties' presentation on preliminary objections over the last 3 days have already lasted longer. Armenia once again referred to more than 40 pieces of correspondence and 7 rounds of bilateral meetings over a period of 10 months. But that alone does not prove any negotiations. Armenia is trying to make a mountain out of a molehill. And in Armenia's imagination, the mountain seems to be growing. Thus, Armenia's agent yesterday spoke of 1 year of negotiations. Armenia took issue with the exclusion of pre-negotiations from the concept of negotiations, claiming that this had no grounding in the jurisprudence of the court. It is correct that the court has never expressly addressed the question of pre-negotiations. The reason is simple. This is the first case in which the question arises. The court has, however, defined what it means by negotiations. In Georgia versus Russia, the court held that negotiations require that the parties engage in discussions with a view to resolving the dispute, and that the subject matter of these discussions must relate to the substantive obligations under cert. Now, procedural and technical exchanges clearly do not relate to the substantive obligations under cert. While the court thus has not expressly excluded pre-negotiation from the concept of negotiation, this is the logical consequence of applying the court's definition of negotiations. Armenia's suggestion to treat exchanges relating to procedural and technical matters as negotiations, as long as they may be made with a view to resolving the dispute, does not make any sense. The whole purpose of negotiations is to resolve the dispute. Procedural exchanges cannot achieve that. If pre-negotiations were enough to satisfy the negotiation precondition, the parties would not have to engage in any substantive discussion at all. Armenia also questioned the need for 7 months of pre-negotiations. Mr. President, members of the court, let me remind you of the circumstances in which these pre-negotiations were held. Since the breakup of the former Soviet Union in the early 1990s and Armenia's attempt to seize large parts of Azerbaijan by force, the parties had not been on speaking terms. There were, and still are, no diplomatic, cultural, or other relations between the two states. The parties had fought 2 bloody wars and engaged in countless military skirmishes. Armenia had illegally occupied about 1/5 of Azerbaijan's internationally recognized territory and had expelled more than 1 million Azerbaijanis from their homes. For almost 30 years, the parties had not talked to each other directly without a mediator. There was nothing to build on, no trust, no common ground. The parties basically started from scratch. These technical talks were much more than pre-negotiations. They were an exercise in confidence building and tentative rapprochement. The situation between the parties is different from any other third case that has ever been before the court. Against this background, it becomes clear that the parties could not and did not immediately engage in discussion on the substantive obligations under third, but that they had to prepare the ground first. These pre-negotiations were by no means diktats imposed by Azerbaijan, as now claimed by Armenia. The procedural modalities, as well as the schedule for the presentation of the parties' position, were agreed upon by the parties after several months of exchanges. As I explained on Monday, Azerbaijan on several occasions requested more time for the substantive discussions, but Armenia only agreed to an abridged schedule that allocated just 2 days each for the presentation of the parties' positions. Azerbaijan has also accepted Armenia's suggested modification to the schedule for the talks. There can thus be no question of diktats by Azerbaijan on when, where, and how the negotiations would proceed. Armenia faults Azerbaijan for offering to facilitate the return of the forcibly displaced rather than to allow their return, to take steps to provide rather than to guarantee equality before the law, to assess educational material rather than to adopt immediate measures to change them. Armenia, however, deliberately overlooks that these were just first counter-proposals accompanied by an express offer to discuss and consider other reasonable proposals. Armenia is correct in that it was not obliged to accept proposals that it did not consider adequate. However, it was obliged to engage with them and not simply walk away. Contrary to Armenia's claims, urgency and an imminent risk of prejudice to plausible third rights does not absolve a party from fulfilling the negotiation precondition. Urgency may give rise to provisional measures, but has no bearing on the jurisdictional requirement under third. Let me conclude by addressing the elephant in the room. Azerbaijan's own case against Armenia. Can Azerbaijan's application go ahead while Armenia's application is dismissed for lack of jurisdiction because it does not fulfill the negotiation precondition? The short answer is yes. The reason is simple. there are several important differences between the two applications. First, Armenia has not objected to the court's jurisdiction on the ground that the negotiation precondition is not fulfilled. Azerbaijan has. Second, unlike Armenia, Azerbaijan engaged in substantive discussions by making specific counter-proposals to Armenia's requested remedies. Although Azerbaijan rejected Armenia's claims, it nevertheless made specific counter-proposals for remedies in order, I quote, to resolve Armenia's alleged claims. Azerbaijan also confirmed its willingness to discuss these counter-proposals and to consider any other reasonable proposals put forward by Armenia. There was thus clearly evolution with regard to Azerbaijan's position. Azerbaijan also not just proposed possible remedies to Armenia's claims, it also addressed Armenia's concerns regarding the military trophies park. At the session on 31st of August 2021, Azerbaijan's delegation made the following proposal, and I quote, acknowledge that the use of monikers to depict Armenian soldiers in the military trophies park inflamed tensions between the two states, and in the interests of moving forward towards a sustainable peace, Azerbaijan could consider removing some monikers depicting Armenian soldiers and ensure that the park tour guides do not use inflammatory language inciting discrimination against Armenians. End of quote. It is thus misleading to say, as Armenia did, that only the threat of provisional measures by the court made Azerbaijan remove the monikers from the park. A continuation of the discussions would probably have achieved the same result. Third, Armenia rejected Azerbaijan's claims outright, and at the meeting of 15 September 2021, declared that it was not willing to provide any remedies to Azerbaijan. There is thus no question that the negotiations on Azerbaijan's claims had become futile. As the Permanent Court held in Mavromatis Palestine concessions, negotiations become fruitless when one of the parties definitely declares himself unable or refuses to give way. That is exactly what Armenia did. The two cases are thus not the same. While Azerbaijan engaged in good faith in negotiations, Armenia did not. The difference is between the one ready at the negotiating table and the other walking away. It is for that serious reason that Armenia's application must be dismissed for lack of fulfilling the negotiation precondition. I thank the Court for its kind attention, and Mr. President, may I now ask you to call on the co-agent to present Azerbaijan's final submissions.
I thank Mr. Salman for his statement. I now invite the co-agent of Azerbaijan, His Excellency Mr. Rahman Mustafayev, to take the floor. And allow me, Mr. Mustafayev, to draw your attention to the fact that Azerbaijan already exhausted all the time allocated to it, so if you can be as brief as possible.
Monsieur le Président.
Mr. President, Madam Vice President, members of the Court, I have the honor to appear before you as co-agent on behalf of my country, the Republic of Azerbaijan, in order to present its final submissions.
Azerbaijan has appeared before you this week as a good faith litigant with the sole objective of explaining to the court why, in its submission, Armenia's application misuses the cert and tries to escape its obligation to make a genuine attempt to settle its dispute with Azerbaijan by way of negotiation. I trust that we have achieved that objective. By contrast, as we have heard this evening, the Armenian side yesterday devoted a substantial portion of its speeches to presenting a highly misleading and unreliable, fatal or nothing to do with Azerbaijan's specific preliminary objections. If anything, when viewed carefully and in its context, much of the evidence cited yesterday on the slides presented by Armenia positively demonstrates that the claims that are the subject of Azerbaijan's rasioni materiai objection have nothing to do with racial discrimination, and thus are not capable of falling within cert. In my capacity as co-agent, I have one further distortion to add to the list of the evidential distortions by Armenia that were identified by Mr. Oki earlier this evening. It relates to the so-called Azerbaijani military patch displayed by Armenia's council at its slide SM5. Yesterday, Armenia's council posed the question, and I quote, "Do normal belligerents, as part of an armed conflict, have soldiers who wear patches that say, 'Armenian, don't run, you'll die anyway, just exhausted'?" Azerbaijan's answer to that question is a categorical no. I can reassure the court that no such military badge has ever been displayed or used by Azerbaijan's armed forces. Armenia's source for this image is a Facebook page with no link to Azerbaijan or its military. Mr. President, this evidence emphasized by Armenia's